privilege for me to speak on this subject because due to basically one reason, and that reason is that the subject is very close to my heart. But, and then there is another reason also that today people are openly talking about the lethargicness of the judiciary, laziness of the judiciary, attitude of the judiciary. And this is something which even I wanted to say, but it was glad that people have spoken about it. There are two reasons more, or three reasons more, which I wanted to point out before I come to the given topic. And the three more reasons are: first is that judiciary is acting mechanically and not in terms of the facts and circumstances of the case, which is required by our laws, CRPC or IPC. That you have to act in terms of the facts and circumstances of each individual, facts and circumstances of the case. But what is happening? Judiciary is acting mechanically. The second point is regarding the presumption of guilt prevails over the presumption of innocence. Once an accused is brought in the court, it is presumed that the person is guilty, he must be convicted and sentenced. It is never thought that this person is innocent, he might have been falsely implicated, although the judges know that. Because the judges think that it is the plea of the defense lawyer that this person has been falsely implicated. And there is third reason, which nobody in fact pointed out, a little bit was pointed out by Advocate Ananta Sthana in his speech, that lawyers are also not acting promptly. It is also the role of the lawyers because we are the officers of the court. And lawyers can also bring about a major change in the system. Section 309 of the CRPC, I think this section is very important for all the lawyers. And this will actually help in precipitating the trials. All the prisoners who are inside the prison, there is special provision, not in fact special provision, this provision is for all the trials. And 309 very categorically says that evidence, once the evidence starts, the evidence shall go on continuously on day-to-day basis. And if an adjournment is given, the explanation has to be written, has to be made in writing. But you will not see any lawyer making application that my case should be tried on day-to-day basis, witnesses should be examined on day-to-day basis. If this provision is applied by the lawyers, I can assure you that we will also have the great success rate in terms of the prisoners. And prisoners will be released in the 1 or 2 years. They will not be released in 10, 20 or whatever, 15 years. Now I will come to my points, the topic which was given to me. And the topic is, I'll just tell you some of the judgments. And I will very specifically tell you about the rights of foreigners and rights of persons with disabilities. I primarily work for criminal justice system and persons with disabilities. And there are two judgments which are, one is with respect to medical facilities to the persons with mental illness. This case was in fact initiated by one magistrate. When the magistrate came to know that one lady had a lot of, was suffering from mental illness, and she in fact tried to commit suicide and all these things. So she referred this person to the mental illness institution, and she wrote a letter to the Chief Justice of Delhi High Court. Thereafter the matter was taken up. IVAS, the mental institute, was included. But the IVAS was directed to draft the guidelines so that persons with mental illness can also enjoy all the medical facilities which are available outside the prison. Because neither they are able to enjoy the prisons inside, nor are they able to enjoy the prisons which are available for them outside the prison. So this is one case which, and thereafter, nothing happened. IVAS did not frame any guidelines. Then SNEHI, an organization, again filed this case, and IVAS assured them that the guidelines has been framed. However, still these guidelines is not in the public domain. This is one case, Snehi versus State of NCT of Delhi. Now there is another case which was regarding the facilities, aids and appliances like wheelchair, crutches, etc. to the persons with disabilities, physical disabilities. This is concerned action versus State of NCT of Delhi. And in this case, RTIs were filed and all this happened, and thereafter it came to know that it was known to the applicant that persons with disabilities are not being given aids and appliances, wheelchairs, crutches, etc. Even if they are given, then one wheelchair is used by two persons, that is also broken. If the crutches are given, the rubber sole of the crutch is not there. All these things were there. So the case was filed to appoint liaison officer for persons with disabilities in the and sanctioning of budget for the prison administration to improve the conditions of persons with disability, etc. These are two important judgments which focus. Do I have time to speak now? So these are two disability judgments which in fact tell us that the concerns of the persons with disabilities were never taken into account. There is one more judgment with respect to the foreign prisoners. As you all heard today in the morning, that legal aid is available from the point of arrest, which was held in Kasau's judgment. But it is also very important for all of us that in one of the judgment, that is Muhammad Hussain Zulfikar versus State of NCT of Delhi, it was held that even the